Meanwhile, in light of the Michael Sussmann acquittal yesterday, I want to bring in Bob Bianchi, criminal defense attorney and anchor at Law and Crime Network, for a legal perspective on all of this. Bob, thank you for being with me. So, as we all know, Michael Sussmann was acquitted yesterday of lying to the FBI, former Clinton lawyer, regarding the Trump-Russia collusion hoax. What are your thoughts? I'm sure you kept up with the trial and you have a lot to say about this, so I'll just hand it off to you. What do you make of this verdict?
Well, one of the things that interested me is, first of all, it's in federal court, so we never get a live perspective, which is such an antiquated system. So we have to rely on the articles that the news media is putting out there. So what I do as a legal analyst is I try to cross-relate, go to all sorts of different sources to try to get the best perspective I can on what's really occurring factually. So from the very beginning of this case, it's a difficult case for the prosecution to prove because you have to prove that a person lied, and you have to prove also that it was material, that it materially affected the outcome of an investigation. So as a former prosecutor, anytime you're bringing something forward with regard to perjury or lying, you know you're going to have a difficult time because a lot of it deals with state of mind. So the question becomes, is there independent evidence to support whether or not the person was lying? So basically what Sussmann's team argued here was that he was just going in as a quote-unquote concerned citizen. And while I understand from a political or perhaps even moral point of view, people be agitated like, oh, come on, what are you talking about? He's with the Clintons. He clearly was doing this on their behalf. I have to say there was a note. Again, we wish the FBI would record interviews like most prosecutors do in the state courts, but they don't. They take notes. And in the note, it indicates Michael Sussmann, and I'm reading from it, represents DNC, Clinton Foundation, etc. And then there's a little arrow that the FBI agent wrote, or the person who wrote this note, that said, not doing this for any client. So the question becomes before the jury, well, can a person who's political act as a concerned citizen? The law is clear on that. The answer is yes. And the question here was whether they could prove beyond a reasonable doubt to 12 jurors that no, he lied when he indicated that he was acting on his personal behalf. Now, last note that I'll make there that is very important, because the jury asked for this during deliberations, were taxi records that were used to and from the FBI meeting, which did not go to the Clinton campaign and did not go to the Clinton Foundation or anybody associated with the Clintons, but rather to his own law firm, which I think is the jurors asked for that specifically because to them that was independent evidence. At least, let's put it this way, it didn't prove beyond a reasonable doubt. Had these bills gone to the Clinton campaign or foundation, that would have been a big problem. So overall, I know people are very hot about this particular case, but I'm looking at it from a narrow focus as a trial lawyer. It was a tough case for prosecutors to prove, and you had 12 jurors that were in unanimous agreement that it wasn't proven beyond a reasonable doubt.
Yeah, and I do understand that a lot of people are very upset about it. I'm pretty skeptical about the verdict because it is a federal jury. It is Michael Sussmann. He's got ties galore with the deep state. He's affiliated with Hillary Clinton. God knows what she might have gotten away with in the past. So I'm pretty skeptical about the outcome of the verdict.
Well, one thing I'll say that I was kind of surprised at as a trial lawyer was, look, I mean, we go to court, we put our evidence on. Sometimes you win, sometimes you lose, and hopefully it's a fair trial. What concerned me a little bit about this case that I felt was somewhat unusual was some of the jurors that were allowed to stay on the jury. Now, the government can use what they call peremptory challenges to remove these people, but a number of times they asked the judge to remove some of the jurors for cause. One in particular, that they were donors to the Clintons, even though this wasn't quote unquote, the judge narrowed the evidence with regard to what they could hear about the Clintons. The person was a donor. When the judge asked, okay, even though you're a donor, could you be fair and impartial? This is the typical thing a judge asks. This juror said, I'll strive for impartiality, which is clearly not a full-throated, I will be impartial. So I've been in this very situation. You can look at it as nefarious. Maybe the judge is skewed towards the Clintons or not, where you wring your hands saying, gosh, it's clear that there were 3 or 4 jurors that I would have hoped the judge would have just said, you know what, I'm going to remove them just to avoid any appearance of impropriety, although that is not the standard to remove a juror. But that one juror in particular didn't get that full-throated, I'd be impartial. So there were some concerns in my mind with how the jury was picked.
Yeah, and that is concerning. I really appreciate you sounding the alarm on that for our audience. Bob Bianchi, thank you for being with me.
My pleasure. Thank you.
Coming up next,